as it's 1:30, I'd like to get started right away so that we can be out on time. I just wanted to remind people, please, to ensure that they do fill out the evaluation forms. We really, really do read them and take note of the comments, and we even sometimes write people back if they're really bad comments. But on this program, I'm sure they're all going to be excellent. The other thing I wanted to make note of is that Mr. Justice Campbell has brought one additional page for his paper. It's some additional reference material. It will be out on the registration desk, and you can pick it up during the coffee break. So don't forget to pick up this piece of paper, okay? With that being said, I'll have the afternoon panel start.
The next portion of our program will focus on the matters relating to charter procedure since the Ontario Court of Appeal decisions in Kutiniak and Loveman. For as many questions as those decisions answered, they have left open many additional questions, and they are continually being reviewed by our courts throughout this province and, in fact, throughout Canada. In this regard, we have a panel that should be able to provide you with considerable assistance, and the paper that you'll see in the materials is also of use. Members of our panel are the Honourable Madam Justice Patricia German. Madam Justice German has been a member of the Ontario Court of Justice since 1979, and over those years has dealt with charter matters, all sorts, and I know that she will have comments that will assist you. In addition, we have a representative from the Ontario Court of Justice Provincial Division and a classmate of mine from Osgoode Hall of 1977, the Honourable Judge Ian McDonnell. Ian was a member of the Crown Law Office between 1977 and 1988, and he's been a provincial court judge since that time. And I know that he is very astute with respect to charter matters, has participated in a variety of educational programs, and will have comments as well that will assist you. On the Crown's behalf, we have John McMahon. John has been practicing since 1983. Between 1984 and 1993, he was an assistant Crown attorney in Scarborough, and best known for his prosecution in Regina versus Baltovich, a matter which had some publicity in this community and I'm sure in others. John has recently taken over from Brian Gover as the Executive Legal Officer for the Ontario Court of Justice. Chairing the panel is Mike Neville. Mike is another of our Ottawa visitors. Mike has been practicing since 1972. He was a law clerk 72 to 73. He's a past president of the Ottawa Carleton Criminal Lawyers Association, and I can advise you from my own knowledge, he has organized over the last number of years an excellent educational program there that's run annually at Montebello, Quebec. And so I give you our panel on charter procedure.
I only have one small correction to Jeff's introduction. Are these mics working? They working? Can you hear us? Yeah. I only wish I was the past president. I'm still. Don't laugh, Edelson. You're next. It's one of those positions that once you're in, you can't get out. I hope I can make it through this next hour. I've been fighting the flu for the last day and a half, and my voice may give out, but we'll do the best we can. Charter procedure is becoming increasingly important, perhaps more particularly as a result of the decisions in Kootenai and Loveman. In preparation for this conference, what John McMahon and I did was we sort of divvied up the work that I would do a paper that you've got, and we also designed a questionnaire that we circulated to a fairly large number of jurisdictions to get some kind of a snapshot of what's happening procedurally in the province, and John in particular is going to give you some of the highlights of that, and it's attached as an appendix to the paper. As I do indicate in the paper, the notion of procedural intricacies is a new one for most criminal lawyers. By and large, except for appeal work and perhaps extraordinary remedies, detailed procedural rules are rather foreign to criminal practice, and I suspect that's why at least half of the people in this room do criminal law, including myself. It wasn't a paper chase. That may well now be changing, and the necessity of being aware of procedural demands may be much greater than it ever was before. The impetus for the change is, I guess, twofold. In 1992, the General Division proclaimed procedural rules under Section 482, and in particular Rule 27. That deals with charter motions that deal with the validity of a statute on constitutional terms and any application where you're seeking a stay. Now, we'll come back to that because that obviously has some significance in terms of timing. The provincial division, as everybody knows, does not have a set of formalized rules, and John will give you some notion of what's happening across the province, which is pretty much a hodgepodge, although it's surprising what is happening in some areas. In terms of judge-made law, which is the primary source of law in the exclusion of evidence area, the starting point now, at least for Ontario practitioners, is Kootenai and Loveman. Now, the importance of these two cases is in several areas. For those who are, and I suppose most people here are, in Kootenai, we had a situation where the defense apparently had full disclosure, knew essentially all the issues. It was a drinking and driving type of case where at the end of the Crown's case, with no prior notice to the Crown, the court, defense counsel stands up and says he wants to have a charter application, a charter of voir dire to exclude the evidence that had already been admitted without objection. So a lying in the weeds or an ambush type of application. In Loveman, it was a little different, although again it was an exclusionary situation. At least prior to trial, the Crown had been advised in a somewhat informal way that the defense was going to question the admissibility of certain evidence vis-a-vis the use of the alert machine, although not specifying it per se in terms of Section 8 or 9. In both cases, the trial judges denied the opportunity to have the voir dire, and eventually both cases made it to the Court of Appeal. In Kootenai, the Court of Appeal agreed with the trial judge, who had also been upheld by the Honourable Judge Borens in the Summary Conviction Appeal Court, that in the particular factual and legal circumstances in Kootenai, it was appropriate not to permit a voir dire because on the state of the evidence, there was clearly neither a legal nor a factual foundation for one. There simply was no violation at all apparent. In Loveman, the Court of Appeal reversed and basically said that there was a foundation, the Crown had sufficient notice, and the Crown's case wasn't in any significant way altered by the application to exclude evidence under the Charter. Now, as a result of these two decisions, however, there are some fairly significant consequences I think we practitioners have to be aware of, and I've itemized them in a summary form at pages 17 and 18 of the paper. And they're basically these. The defense should give notice on a timely basis to the court and the Crown of a proposed charter application. The defense should be in a position to particularize in the notice the basis of the application, in other words, what section or sections. If the court, presumably on the motion of the Crown, is not satisfied with the timeliness or specificity of the notice, there may then be almost a voir dire within the voir dire as to the degree of disclosure and knowledge of the defense of the issue that they want to litigate by way of a charter voir dire, to see whether, in other words, earlier notice and more specific notice ought to have been given. There may be the requirement of an offer of proof. Now, this was one of the more controversial areas in Judge Borens' decision because he set up a very Americanized procedure of affidavits and the like, and that's discussed in the Kootenai judgment as raising difficulties with certain areas such as the right to remain silent. But the court does endorse the use of a form of offer of proof by way of counsel outline. In other words, counsel who's seeking to have the voir dire should be in a position in appropriate circumstances to outline what he or she anticipates will be the evidence and direct it to what sections. If the notice hasn't been timely and/or counsel is not able to give this preliminary offer of proof in a sufficient way to show that a voir dire is prima facie justified, there appears now to be authority in the trial judge to reject or dismiss the holding of a voir dire at all. Unlike the situation in Kootenai, it is also, as counsel did there, is simply not proper where you intend to raise an anticipated charter issue of which you have at least some knowledge, pardon me, as opposed to one that arises unexpectedly. You cannot sit back and let the evidence be led and then stand up, as counsel did at the Kootenai trial level, and say, now I want to apply to exclude it. You have to do it at the time the evidence is tendered or before it's even tendered. And finally, looking at Loveman in particular, there appears to be still, though, a judicial discretion to deal with a charter application where the grounds of the violation appear to arise unexpectedly in the course of the evidence, perhaps in the course of cross-examination, or occasionally, as in the Armour case, through the evidence of the accused. Now, those are sort of the practical consequences that could arise out of Kootenai and Loveman. The one other message that, just in terms of my initial overview, I'd like to give before we turn to comments from the panel is that once you start introducing procedural requirements, in this case in criminal law, and you do it in the form of either statutory provisions such as the Section 482 rules or fairly explicit judge-made provisions such as in Kootenai and Loveman, you are raising the specter of negligence. And I think all counsel should be aware, depending on how strictly the Kootenai-Loveman regimes are implemented and enforced, that failure on the part of counsel to properly give notice, to particularize, and to be in a position of offering an effective offer of proof if called on, if that can be brought home to counsel as caused by his or her negligence, the notion of not only appeals where you are identified as not providing competent defense to your client, but perhaps civil actions is a very real one. And I think the bar have to become increasingly aware that the placing of rules on procedure leads to the consequences of sanctions, both from the court at the trial level and perhaps in some other court on the basis of civil negligence. Maybe I can now ask John, if he would, to just give us a brief overview of what the survey revealed, and then we'll turn to our judicial panelists and see what their reaction to all of this is. John?
Thanks, Mike. What Mike and I did in the late summer was we looked at how are procedurally charter applications being dealt with throughout the province at both the provincial and federal, provincial and general division level. And what I did in August was we sent out a questionnaire to about 25 Crown Attorney's offices. I talked to members of the defense bar in various court locations, as well as judiciary from both the provincial and general division. And the results of that survey were actually staggering at the way procedures vary. It's like in golf where local rules apply. But the one thing that it came up with, basically, is that there is obviously no uniform procedure out there on how to properly bring a charter application, on whose onus the evidence, of calling the evidence, who has the right to cross-examine, what type of notice should be given, if any, and what are the sanctions. And after looking at it, it appeared that there were more problems and more confusion in the provincial division than the general division. And I think that can be caused for two reasons. It's not that the general division are that much better, even.
Watch it.
But basically, they have the benefit, as Michael's already talked about, that at least in the Section 11 applications for stays, that they have the criminal rules, particularly Rule 27, that there's a set format. And secondly, there's the benefit of the disclosure procedure that's happened prior to and the mandated pursuant to the code, that you have to have a pretrial. So a lot of the issues of charter alleged violations are brought home to the court and the Crown long before the day. So it comes out to more problems happening in provincial division. And when I looked at it, the complaints that came across the board depended on which party I talked to. From the defense bar, and I think this is a we have a great deal of practitioners here today from the defense side, The greatest frustration was that since we don't have that standardization, if you regularly practice in Whitby and you have a case in Hamilton, what procedure do you follow? If you're in provincial court, what notice provisions are there? What notice? How do you do notice? Is it oral or written? That was their major concern, and the second concern defense voiced was the issue of whose burden is it to call the police officers and the right to cross-examine. From the Crown's point of complaint, because there is no uniformity, was the issue that lack of notice or sufficient time of notice to have the proper witnesses there, and as a result, cases would be getting adjourned because the Crown didn't have proper notice, and there'd be dead time with the court, where the court would go down because they weren't able to proceed. From the judiciary's point of view, the concern sometimes was the timeliness of the notice, but more often than not, that it wasn't specific enough to allow the judge to properly prepare prior to court to know what the actual violation was going to be, so he or she could focus whatever research time they would have to properly be up on the law. Now, when we went through the particular survey, there were 4 areas where the procedure varied right across the province. There was, what are the notice provisions? And across the province, depending on where you practice, the notice provisions are oral notice on the day of the actual bringing the application, to mandated by a practice direction 30 days written notice to both the Crown and the court. Secondly, the other area where there's mass confusion is on whose onus is it to call viva voce evidence if viva voce evidence is going to be called. We're dealing with police officers. In some regions, the practice is growing up that if it's a police officer, even though it's an application by the defense, the Crown will elect to call that witness and allow the defense to cross-examine. There are other court locations, and they're summarized in that survey, where basically if it's a defense application, they're the ones who are being asked to call those police officers, and in my opinion, you get the ludicrous position where defense counsel is trying to give examination in chief to someone who's adverse in interest, and then you have the Crown coming back and even more ludicrous, cross-examining a favorable witness. Personally, I don't believe that's appropriate myself, but that's what the survey showed. There are jurisdictions like that out there. Michael told me I'd find them. I didn't believe him, but he was right. The third area is the issue of combining, if you have a Section 10B issue of rights to counsel and a charter violation and a voluntary issue. Should they be combined in one particular voir dire, and there's case law on the issue, or should they be separate voir dires because the burden is on each of the, one's on the Crown and one is on the defense? The variations across the province as well are outstanding. Some of them combine them all the time, some of them require separate voir dires. The other one, which I think is equally important and probably most important, because Michael talked about negligence, is sanctions. What happens, and I appreciate we have Kootenai and Loveman, but what happens if you, let's say from Whitby, don't follow the rules of notice when you go to, and it's not picking on anywhere, let's say Hamilton. In some jurisdictions, the remedy provided by the court, and most of this that I'm talking about now would be provincial division, is a refusal or dismissal of the application for improper notice. If that happens, the Court of Appeal in some of these cases has come back, or at least on summary conviction appeal matters, and said that they can't prejudice the accused's rights, and they sometimes send them back for a new trial. On the other hand, at the other end of the sanctions are cases that simply, if you haven't given proper notice, the Crown's going to get an adjournment. The concern, of course, right now is, after we look at all of those 25 locations, and we summarize some of them in the paper for you, there is no uniformity. There's a great deal of confusion, and I think what it comes down to right now, it's frustrating for the practitioner, and it's frustrating for the court and the Crown, because if there's not proper notice, what we're finding is, and the judiciary's major complaint was, lack of proper notice results in adjournments and courts sitting empty when they could be fully utilized because an adjournment had to be granted. So basically, Michael, that's what we've been able to discover.
Judge German, Do you see a brave new world as a result of Kootenai and Loveman, or have you seen any particular change?
Oh, of course, there were great changes. Before Kootenai and Loveman, lawyers used to pop up sort of like dandelions in the grass. You never knew when you were going to be hit with an application for a ruling. And really, I think that was what was in Justice Boren's mind when he wrote the original decision in Kootenai. He was trying to bring some order out of the chaos because nobody really knew what was the correct thing to do. And until Mills, I guess, in the Supreme Court of Canada, we didn't know whether it was the trial judge that was supposed to hear these motions, whether they could be heard by another judge, or what to do, and it was chaos. So yes, it's much better. And in the General Division in Toronto, which is the only one I can speak of, really I think you usually find that the lawyers are cooperating. But remember, by the time it gets to our court, there's been a pre-trial in the provincial court, and there's been a pre-trial in the General Division. So the chances that that the Crown doesn't know that there's going to be a charter motion are pretty limited. If it comes up at the last minute, I doubt that there are many judges in Toronto who would refuse to hear the motion because there hadn't been a notice filed. I think they would be given an adjournment, which is unfortunate, but I think the main thing is you can't prejudice an accused, because I was doing one trial once and nobody had suggested that there should be a voir dire on the statement admissibility, but as the evidence started to come out of the police officer, it was very obvious he had never told the accused that he had a right to counsel. So fortunately, it wasn't a jury trial, and everybody consented, and we just sort of ignored the statement. But that usually I find that the Crown and the defense have gotten together before the trial starts, and they have agreed between themselves how they're going to act. I did one voir dire once, one of these voluntariness and charter right to counsel, and I've forgotten who was being adamant, but we ended up doing two little motions, and I did not care for it. I would never do it again, because you had witnesses being called and examined and cross-examined, and then back up and being examined and cross-examined by the other party, and it was very confusing. So I think now judges, certainly I would, and as far as I know everybody in our court does, they just keep the burden of proof in their own mind and deal in the reasoning separately, but the evidence is called all at once.
If I can ask you a follow-up question, Your Honor, amongst your colleagues on the bench, has there been any getting together to develop a consensus approach to procedure, or is it every man, every woman for himself in her own courtroom?
Oh, I think there's general discussion constantly, and we have education meetings once a month when we discuss problems, and we have seminars, and I think certainly if someone has a problem, there's discussion about it, but I think you generally find, I asked around before this what people do, because it's always difficult when you're a judge. You don't know what your brother or sister judge does. And I found that there was pretty well a consensus that on a voir dire, that if it's possible to go on the anticipated evidence or a statement of facts, that's the way the judge will go first choice. If
as a preliminary offer of proof type of thing? Is that what you think?
No. If credibility is an issue, then of course witnesses have to be called, and usually I think the Crown calls, I have never had an argument about who calls the police officers. The Crowns have always called them.
All right. I guess what I was also getting at is when you look at the Kootenai judgment, I mentioned it in my opening comments, it seems to be provided there that because of for cases in your court, because by that point the defense has had the benefit of presumably Stinchcombe level disclosure, a full preliminary hearing with the rights to explore charter issues that the George decision, the Court of Appeal has set down, and Skogman, of course, prior to that. Then a pre-trial, that by the time you get to the opening of the trial, there should be little of anything from a charter standpoint that the defense doesn't know, and therefore the putting of the applicant through his counsel to the preliminary offer of proof is very much suggested as the way to go. Is that what's being done, do you know?
Probably not often. I think usually the defense counsel will give you a statement of why he's bringing the motion and the particular breach, but and if necessary, you could insist that he put his client in the stand to say, well, what happened? Why have you got this?
All right. Do you know of any particular trend so far in your court, because we're only about, what, I guess a year, just coming up to 2 years into the Kootenack-Loveman era, any tendency to approach it by the way of a preliminary offer of proof, and if insufficient, to deny holding of voir dire?
I'm sorry?
Yes. The Kootenack-Loveman formula appears to say that after the application is announced by defense counsel, the judge has the power to say to defense counsel, give me your preliminary offer of proof. What section and what evidence do you think you've got to support it? And if it's not good enough, doesn't appear to justify a voir dire, there isn't one. Is that a trend that you think is happening in your court?
I have not heard of anybody refusing to hear a voir dire on the basis that there wasn't enough evidence.
Okay.
It may be that by the time it gets to us, those have been weeded out if there isn't enough evidence and defense don't bring them.
Judge MacDonnell, from the standpoint of your court, is there a brave new world post-Kootenack and Loveman, or is it just business as usual?
Well, there's an improved world since Kootenack and Loveman. I don't know that I would characterize the change as being dramatic or anything like that. As the survey that you and John conducted makes clear, particularly in the provincial division, there isn't a uniform practice that has developed, and there are, I think, reasons why it would be less likely to be developed in the provincial division than in the general division, and you talked about some of them in terms of preliminary inquiries and formalized pretrial discussions which occur in that division. But there are things that have changed, I think have changed for the better. Prior to Kootenack, it certainly wasn't unheard of, for example, in an impaired driving case, in the course of final submissions at the end of the case, for someone to stand up and argue that their client shouldn't be convicted, A, because the evidence of impairment wasn't sufficient, and B, because the Crown shouldn't be allowed to rely on some of that evidence because it appears that his rights were violated. That arising for the first time at the end of the case. It also wasn't uncommon, as Justice German points out, for charter motions to arise like dandelions in the course of the trial. It seems sometimes that they were being raised whenever there was anything in the evidence which might remotely resemble a charter issue, that there would be an application brought at that stage, often without much apparent forethought. I think what the Court of Appeal has done is to focus or refocus everyone's attention back on basic principles, and has certainly encouraged people to approach the possibility of raising charter issues before the trial begins. I think notice is much more common now. It's certainly the exceptional case, it seems to me, where a charter issue is raised in the provincial division where there hasn't been notice to the Crown and some level of particularization of it. Further, I think that the Court of Appeal has encouraged trial judges to become involved at the outset in ensuring that there is, or that the trial judge knows what it is that the issue is going to be with respect to the charter. That, I think, discourages raising charter issues on spec in the hope that something may develop. So that because of those developments, which I think are probably fairly general across the province, well, there's no uniform procedure for dealing with them once they come up, that the impact of these cases has been generally positive.
In your court, I presume at your educational conferences and the like, has there been any discussion and any building consensus about the use of preliminary offer of proof and the type of more technical approaches that are hinted at in Loveman and Kootenai?
Not that I'm aware of, no, and I don't know that the difficulty is, I think that in many centers there may be discussions of that type going on within regions, and that may be how practices are developing. And actually, people in this room may know far better than I how those things are developing, but in my experience, at least in Toronto, there hasn't yet been an attempt to come to some consensus as to how we should deal with such things and whether or not everybody should be requiring them.
All right. If the utopian world of the Martin Report ever exists, is that going to change?
I think it will help to a large extent, although I think probably the reality is that even with full disclosure, sometimes it may be unrealistic in many cases to expect the police officer's notebook or whatever else you have to lay out in front of you a breach of the charter. And that I think that absent the opportunity to develop arguments like that at the preliminary inquiry, that there are still going to be difficulties that counsel have giving notice of the suspected violation and articulating exactly what they expect the evidence to be, even with the type of disclosure that's contemplated by the Martin Report.
Is there, and perhaps both judges can comment one after the other on this one, if the disclosure process is regularized and there's good solid disclosure, and of course in general division there's other steps leading up to the hearing, do you envisage getting into situations where the inquiry as to the basis goes on longer than the hearing if it starts in the first place? In other words, you get into a contest between the defense and the Crown. You knew this, no you didn't, yes I did, no you didn't. And they start comparing disclosure notes and transcripts of prelims, and the argument is, whether you have an argument, is longer than the argument.
Gee, I hope not. There's a tendency for trials to get longer and longer, and if we have to get involved in that type of argument, I shudder.
And John, from the point of view of the Crown, again, assuming some of these things unfold, we really have it at this point now, but theoretically in general division. Do you envisage a procedure or a process developing whereby the Crown's first response at a trial to a charter application being announced is to attempt to undercut it in these areas of the offer of proof by showing that, well, you didn't use the preliminary properly, or you didn't get all the disclosure you should have, that type of thing, and try to head it off?
Well, I think reality dictates that sooner or later you're going to be able to bring that application. It's just whether there's been proper notice that's been set up. And I think Martin is going to be used as a two-edged sword, as a Stinchcomb. There clearly has to be a full commitment by the Crown, and now it's going to be mandated for those who don't want to comply, to early, full, and complete disclosure. But I think equally, once that is done, the argument then arises that if defense counsel has been given full and complete disclosure of everything the Crown has, that there's going to be, after Loveman and Kootenai, a requirement that if you're going to be bringing these applications at court, you are going to have to provide notice. And I think, as opposed to saying at the end of the day, well, you had this and you haven't made anything, you haven't brought an application until, and you're only entitled to bring it at trial, you can't bring it obviously at the preliminary hearing stage. I think what's important in the whole procedure is that that notice is going to have to be required. And as a Crown, from a strategical point of view, I'm not going to try to stop the application from taking place, but far as the weight that should be given it, it can in fact be limited if at the time of the actual application that they don't have a case there. I mean, if the offer of proof isn't there and you've given them full disclosure, if Loveman and Kootenai's followed, that you can short circuit it by saying they have everything, prima facie, they don't have the case there, let's not waste the time for voir dire. I think that may be something that happens that has not yet developed out of Kootenai and Loveman, and I think one of the reasons is defense counsel fairly say, geez, I don't know all the facts yet because I don't have complete disclosure.
All right, well, just so everybody knows where we're coming from on this one, let me just read this passage from the Kootenai judgment. I think it would be a rare case where the Crown has provided full disclosure, the accused has had an opportunity to have a preliminary inquiry, and the matter has been thoroughly pre-tried, that the defense would be unable at the outset of the trial to outline the nature of the alleged violation and to summarize the nature of the evidence counsel will call on the application. Armed with this information, the trial judge can weed out the applications which have no basis in law, in fact or law, and can decide how and when those with potential merit should be resolved. If, on the other hand, it should appear that the accused has not taken full advantage of all the opportunities available to him to be apprised of the case against him in the light of the defenses available to him, then he should expect little sympathy from the trial judge when he asks for permission to explore a charter remedy. Now, does that not appear to lay the foundation for the Crown's tactical approach that you've just discussed?
Well, I think quite clearly it does. As I said before, is that because of that disclosure, you're going to hopefully be able to say if everything's been done prima facie, is it there or is it not? Is it worth the judge going into the voir dire? That procedure hasn't, to my knowledge, developed that far at present, even though it's talked about in the case. But I think it's coming, because why, if on the circumstances, since there has been full disclosure, everything's on the table, and if you can't summarize it in enough to get the judge's attention that there's an issue, why should we waste the time of a viva voce hearing?
Judge German, I'm going to come back to you again if I can. In the light of that passage, can you envisage that type of approach to charter applications in your court, and how would you feel about it?
Oh, absolutely, if I can see that happening. At the moment, I don't think it's occurring because where I see it happening is in the trial is just about to start and the defense counsel will stand up and say, my friend has just given me something or just told me he's going to call a different witness and I'll need some time. So it leads to an adjournment. But with the fuller disclosure that's certainly going to take place, then I think there will be a threshold that the defense will probably have to meet before you embark in a voir dire.
All right. Judge MacDonnell, what about in your court?
Well, we're the exception to the rule that Justice Finlayson was talking about, in that I think traditionally the disclosure practices haven't been as thorough in the provincial division. There's no preliminary inquiries, and the pretrial process up until recently was certainly less rigorous than in the general division. So that it seems to me that it's fairly easy to make a case in our court that counsel's inability to articulate exactly what the breach is and what the offer of proof is should be forgiven.
All right.
I think perhaps what I was trying to say is that I don't think we would allow fishing expeditions. If there is something there, then certainly we would hear it. But if counsel doesn't know it by then probably not.
Well, what about the notion, though, that the defense files the application, they announce they're bringing it, and what you end up with is a contest between the defense counsel and Crown counsel as to whether the defense has done their homework? Can you envisage that, where the Crown will be saying, well, they didn't explore this at the preliminary hearing, here's the transcript, they didn't ask any of these questions, now they want to call this officer and establish a Section 10 violation. They didn't do anything about it at the preliminary hearing.
I think the bottom line would be if the accused is going to be penalized, you would probably have the voir dire to hear it.
How would you feel about coming up to sit in Ottawa?
Best offer I've had today.
Perhaps we can deal with a couple of other areas next. Types of applications, and perhaps starting with you, Judge MacDonnell. In terms of timing, what is the significance from the point of view of timing, depending on the nature of the application, be it one for a remedy for delay versus a stay of proceedings for lack of ability to make full answer or defense versus exclusion of evidence.
Well, I think that there's a couple of cases recently in the Ontario Court of Appeal that that people should be aware of in relation to timing with respect to Section 24(1) remedies. So remedies for stays on the basis of delay or inability to make full answer in defense, absence of a fair trial, that sort of thing, where delay is the basis for the application for a stay, and where what is being said is that the delay has impaired the right to a fair trial or the ability to make full answer in defense, then it appears that the court shouldn't decide the motion at least until the conclusion of the Crown's case and perhaps until the end of the trial. And those cases are Francois. The citation I have for is 1993 Ontario Judgments number 2103, which was released September 20th of this year, and Regina versus DJB, 1993 Ontario Judgments number 1662, which was released on July 15th. In Francois, Justice Finlayson for the court said as follows. He says, whereas here the respondent contended that the delay so adversely impacted upon the fairness of the trial as to constitute a breach of his Section 7 charter rights, it is not apparent to me how this complaint can be evaluated without a trial. In my view, the appropriate course for the trial judge in this case would have been to reserve on the motion for a stay until after the trial, or at least until the Crown had closed its case. The trial judge would then have been in a position to assess the cogency of the witnesses and assess the damage to the defense said to be caused by the delay. Now, the application in that case was brought under Section 7 and Section 11D, not under Section 11B, because it involved pre-charge delay, which doesn't of itself give rise to an infringement of Section 11B. But the proposition which Justice Finlayson pronounces may or may not be applicable to cases of purely post-charge delay, that is, applications brought squarely under Section 11B of the Charter. And I think it depends on whether or not the applicant is alleging as a component of the prejudice that he or she has suffered that his ability to make full answer in defense has been infringed. If he's alleging that, and if that prejudice, if real, would make a difference on the application, then it seems that the court should reserve on the motion until the end of the case. On the other hand, if the delay motion doesn't involve any assessment of the prejudice to the trial, which hasn't occurred yet, but is based solely on events which have happened, events which are over, past conduct, and many delay motions are exactly that, then the principle in Francois, it seems, wouldn't apply, and there'd be nothing to stop the trial judge from proceeding to dispose of the motion at the outset of trial. What Francois and DJB may mean for the timing of the application, however, I think, is that the application should still be brought at the outset of trial, particularly if you're going to be asking the judge at the end of the case to make the assessment as to whether or not the right to a fair trial has been prejudiced by something that happened prior to trial. The judge will obviously be in a much better position to assess that at the end if the judge is alerted at the outset that that's happened. There's one other circumstance in which timing becomes important, and there's a case referred to in Mike Neville's materials called Regina versus Martin. This is another decision of the Ontario Court of Appeal in which a challenge to the constitutionality of the statute under which the accused was charged was brought at the outset of trial. The trial judge heard the motion, ruled that the statute was unconstitutional, and the accused was acquitted. The case was appealed to the Court of Appeal. The Court of Appeal ordered a new trial. They disagreed with the trial judge in relation to the constitutionality issue. But in the course of doing that, the court expressed its concern with the timing of that application as well. And Justice Griffiths for the court stated, and I'm quoting, that the trial court should not at this early stage entertain or dispose of an application to enforce a remedy under the Charter, except in those cases where it is abundantly clear that a constitutional right has been infringed or threatened. And he went on to say that the trial judge should have declined to enter into the constitutional issue at that stage at the stage of a pretrial motion, and should have left it to be raised by way of defense at the end of the trial. Now, there have been other cases, and again, Mike's paper refers to them, which I think have qualified the generality of what appears to be said in Martin, but the concern is still there if you're bringing the motion that you may have to wait until the conclusion of trial to bring it. In relation to Section 24.2 remedies, I think that the question is a little simpler in that I would have thought that Kutnick now makes it abundantly clear that concerns with respect to the admissibility of the evidence, whether it should be excluded, should be raised and dealt with at the time that the evidence is proffered by the Crown. Now, there's a fair trial component, obviously, that arises even with respect to Section 24.2 matters, but the concept of fair trial that's referred to with respect to that seems to me to be a different or a specialized concept of fair trial, a little bit different than the one that has led the Court of Appeal in the cases that I've referred you to suggest that maybe it should be waited, that maybe the matter should be deferred until the end of the trial.
In terms of practices in your court, Judge MacDonnell, where you've got a statement at issue, and there may be voluntariness components and 10B components, what's your practice, and if you can comment on it, if there is a prevailing practice in your court about whether there's one voir dire, two voir dires, that is to say discrete voir dires on each component, and then perhaps that can flow into your view on the question of who calls the police and who gets to cross-examine them.
There's, first of all, it appears from the survey that there's a mixed practice out there with respect to whether or not there's one voir dire or two voir dires held. Certainly my practice is to hold two, and there's as John pointed out earlier, authority for that. The Court of Appeal, in an obiter comment perhaps in Regina versus Voss from a few years ago, said very clearly that there should be separate hearings in form as well as concept if there's an issue with respect to voluntariness and right to counsel. And as Justice Tarnopolsky, who made the comment in that case, said, there's more involved than simply a question of different onuses in relation to the matter. There are quite different issues that have to be dealt with. And so that's certainly my practice. Now, it is often very desirable from a defense counsel or an applicant's point of view to try and have the applications blended in one form or another because it gets around the issue which you asked at the end, namely who calls the witnesses and do you have a right to cross-examine if the applicant is forced to call those witnesses. I think that the idea that the Crown is going to call the witnesses on the charter motion arises because, at least in our division, most of the charter applications come up in one of three contexts, either a drinking driving case or a statement case or a drug case. In a drinking driving case, the Crown has to normally account for what happened after the arrest and before the sample was taken. One of the things that happened in there normally is that rights to counsel were given or not given, and an opportunity was or was not afforded to the accused. So the issues substantially overlap, and the Crown often, to convenience the court and defense counsel, will elect to simply call its case and allow the cross-examination to occur. The same thing obviously occurs in statement cases where the Crown has to account for what happened to the accused after he was arrested and before the statement was taken, which again is the same time period covered by the Section 10B issue. And in drug cases, most cases in the provincial division at least involve warrantless seizures of drugs, and the fact that it was warrantless is usually not an issue, which means that the onus in any event shifts to the Crown, and that of course includes the burden of calling evidence. And so normally the question of who calls the witnesses isn't a live issue. I think if it does become a live issue, there's no question but that the person who is seeking the remedy has to call the witnesses. And that's basic principle, that applies there. The onus is on the applicant to establish a breach, to establish the right to the remedy. And it seems to me that the witnesses would have to be called. The question of cross-examination, I think as a practical matter, it's much the same as John pointed out, that John and most Crowns feel that it would be inappropriate for them to be cross-examining a police officer simply because the defense has had to call the witness. And it may be that in most cases, although as Mike makes clear, not in all, that the court would be inclined to grant leave to the applicant to cross-examine the officer. But I think, again, that if leave is granted, it's not because it's a charter case and special rules apply, and it's not because this is a police officer and special rules apply to police officer witnesses. I think that the ruling has to be made, and counsel have to seek the ruling that the witness is adverse. In a charter case, having regard to the nature of the issue, namely whether or not the police have infringed your client's rights, it normally wouldn't be too hard to get a finding that in the context of this proceeding, that's an adverse witness and to get the leave. I think you have to do it. And there's some authority for that, again, in Mike's materials, which have been very helpful. He refers to a ruling of Justice Donnelly in the Moran case, one of the many pretrial motions brought in Moran. I think it was ruling number 29 at page 464 in Quick Law, if you want to scroll through it. But in that case, there was an application brought for exactly that form of order, namely leave for permission to cross-examine the police officer on a charter motion, which implicitly supports the position, at least, that if you want to do it, you should ask the court before you do it.
One of the issues near and dear to every lawyer's heart is costs. Judge German and Judge McDonnell, do you see a significant role for costs in criminal law as a sanction either way in charter applications? Judge German?
You mean we'll pay them extra if they do a good job?
We really do want you in Ottawa, believe me.
Oh, I think trial judges would love to be able in criminal cases to penalize counsel that they felt were not doing a proper job by costs, but I don't know, perhaps you could get in touch with legal aid and say, dock this lawyer half a day's pay or something. I'm not too sure quite how it can be done. John McMahon says it's frequently done that the Crown has to pay costs, but I'm not I'm not aware of it being done frequently. Yeah. It's certainly something that if we ever get to the stage where the rules are being enforced strictly, then you have to have some way to put some teeth into it, and that's one way to do it.
John, what do you say about the role of costs as a sanction mechanism in charter applications for either side?
For either side. We see it happening now, and frequent's probably not a good choice of words, but it's happening with more frequency than it has. Material non-disclosure, adjournments, cost to an accused, costs have been awarded against the Crown. In charter issues where you have a court sitting and ready to go and notice hasn't been provided, and because notice hasn't been provided, a court sits empty, where full disclosure has been done, and it basically comes down to the negligence of the lawyer. On the defense side, the question becomes, what, if any, sanction is there that could be used? Now, there's some jurisdictional issues, obviously, about ordering costs at any time, but clearly from what's happened in Kootenai and Loveman, and generally I think trial judges would be very leery to prejudice an accused's right to a full and fair hearing because of negligence of counsel by not filing a notice. But if the court is going to stand empty, the question is down the road, and I think as we come into tough economic times, as I put it out as a suggestion when we got together, I said, who's going to pay for that when we got the taxpayer picking up the tab X $1,000s for it because of someone's negligence? And I think there has to be some sanction which doesn't prejudice the accused, because the accused can't be prejudiced, but if a court sits empty, I'd like it at least to be canvassed jurisdictionally as to the power to do it and whether there'd be a way to do it which it wouldn't reflect back on the accused. But maybe that's just pie in the sky hope.
All right. Judge McDonnell, in provincial court, particularly in your jurisdiction, is there any concept of sanctions at all for inadequate charter presentation by either side, or is it just the adjournment?
Well, it tends to be, I think that the difficulty is that nobody's been able to think of what sanction there could be short of refusing to hear the application. And for reasons that I think everyone can understand, courts are reluctant to completely shut out an accused applicant on a technical ground. Because of that reluctance, there doesn't seem to be anything else that can be done, aside from chastising somebody. I don't think that a judge of our court would have any jurisdiction to order costs. I don't believe any power to do that. One thing that may change in the future, though, is with respect to the reluctance to shut out the applicant for failure to comply with the requirements. And that will be if there is enacted a rule of practice or practice direction or rules of court, because I think that may change the situation somewhat. In Loveman, the Court of Appeal made it very clear that the sanction that was applied there was one that should only be applied as the last resort. If there was really nothing else which in fairness could be done to preserve the integrity of the system, well, then you could shut out the applicant for failure to give notice. But I think that the court made it very clear that a significant factor in their decision was the absence of rules of court and the absence of a practice direction. If there were either of those things, then it seems to me that there has to be an interest in preserving the integrity of the rules and in preserving the integrity of the practice direction, else the procedure that those things are designed to create tends to fall apart. If we get to that stage, then I think that courts will have to give some consideration in the mix to whether or not, by forever forgiving noncompliance in cases of sloppy preparation, whether or not they're undermining the system that the courts have been trying to set up to expeditiously deal with these matters. And in those circumstances, it may be that courts and judges in our division and perhaps in the general division will be more willing to simply say, you are in blatant breach of the rules, and we're not going to hear the application.
Perhaps we'll just close off with a short discussion on one other area that was touched on, I think, briefly this morning in a couple of presentations, and that's the problem of disclosure or lack of it. Judge German, do you agree with the suggestion, which is in the Laporte case, which was mentioned by an earlier speaker and is in my paper, that where there are disclosure problems in the view of the defense at the preliminary inquiry stage, it's appropriate to come to your court for an order against the Crown to give full and timely disclosure?
You mean before the preliminary?
Or while it's on. An issue arises. Under Mills, it appears Judge MacDonnell doesn't have authority to order the Crown to do anything by way of disclosure, so they come up to you on some kind of interim motion.
I probably could have answered that a lot better if you'd given me a copy of your paper before we came, but I wasn't given the survey or the question. I anticipate it could be done, but I may be wrong. I really don't know the answer.
Judge MacDonnell, do you envisage, from your court standpoint, somehow getting to a wider power to police Crown disclosure in the face of Mills?
You mean prior to being seized of the matter as a trial judge?
Yes.
And I don't want to it's an issue which is still being argued in front of us down there with respect to what the powers are. So I'm not sure that I want to say that I agree or disagree with the proposition that I have or haven't any powers at all in relation to that. But certainly, apart from that aspect of it, I think that there is much more of a concern among the judges of our court now to try and ensure that everybody does get proper disclosure, whether or not they do it in a manner that is legally enforceable, if I can put it that way, or whether or not it's simply moral suasion. I think that everyone now is discovering the value of trying to get a handle on what's going on in these cases before they ever come to trial. So to that extent, I think that there's a trend in that direction. But as I say, in terms of what the actual power is to do anything, well, that's a question that I think is still being argued.
I think Justice Watt gave a decision that said you could come to our court if you needed a ruling during the preliminary hearing.
John?
Maybe I was under the impression that clearly the issue of disclosure or lack thereof as a remedy to make full answer in defense would be a matter that you'd have to raise with the trial judge at the time, and that there shouldn't be some form of interim remedy from provincial court to sort of jump the queue and go on a special motion to general division. It would seem that your remedy, at least in my humble opinion and some of the case law, is that quite clearly you have to bring that matter before the actual trial judge and indicate at that time, and if it's caused undue hardship or whatever, the remedy you may seek may be different, but it's clearly a matter within the sole jurisdiction of the trial judge, at least in my opinion.
Thank you for your attention, ladies and gentlemen. We've been given the high sign, and I guess it's time for the next panel. Thank you.